Hey everybody, how's it going? Welcome back to Copper Jacket TV. So we've got a very important video today. The Ninth Circuit Court of Appeals just heard oral arguments in May v. Bonta and Carolero v. Bonta. These are two cases that have been consolidated that challenge California's SB2, which is their Bruen Response Bill. It's the bill that basically bans carry pretty much everywhere in the state of California. This is a case that is extremely important. It was heard before a three-judge panel of the Ninth Circuit, and we're going to talk about what happened and what I think is going to be the outcome of this. So let's get to it. Now, speaking of SB2 and carry, this is the perfect time to announce a new sponsor to this channel, which is Attorneys on Retainer. So what is Attorneys on Retainer? Well, one thing I can tell you is they're not an insurance company. They're actual attorneys who will represent you after a self-defense situation. Now, I do plan to make a full video of why I left their competitor and now I'm 100% behind Attorneys on Retainer, and that's what I'm recommending to you all. But basically it comes down to confidence. I used to have 100% confidence in their competitor, but since then, in the light of certain situations and things that have come out, that confidence has been completely broken. I don't want a third-party insurance company with a bunch of pencil pushers determining whether or not my defensive situation was lawful or not, and whether or not they're going to throw their coverage behind me. With Attorneys on Retainer, whether it's good, bad, or questionable, they are going to represent you. And you don't have to call a call center and have somebody just pick up the phone and you got to tell them all your personal information. With Attorneys on Retainer, an actual attorney picks up the phone, so you have instant attorney-client privilege from that very moment. Attorneys on Retainer will be there to defend you. So it is a huge difference from what I've gone from to what I've gone to. And I absolutely suggest that you make the change as well. If you care about defending yourself, about defending your family, and you care about what happens after that defensive situation. If you guys want to save a little bit of money when you sign up, you can use the discount code CJTV. That'll save you $50 at sign up, and there'll be a link down in the description box. But again, I suggest if you really care about your defense and what could happen afterwards, check out Attorneys on Retainer. Okay, so let's go and talk about what's going on here. So earlier today, we finally got oral arguments in front of the Ninth Circuit Court of Appeals in May v. Bonta and Carolero v. Bonta. These are two cases that are very similar to each other, and so they've been somewhat consolidated, but they both challenge the sensitive location aspects of SB2, which is California's Bruen Response Bill. Now, I'm going to do my best to try and tell you guys what I think the outcome of this is going to be, but keep in mind that that's just based off of my opinion from watching oral arguments in the past and these types of topics and seeing how the Ninth Circuit has reacted in the past and what I saw from this oral argument as well. But the state of California's attorney was up first. And one thing I noticed was the judges in this case, there were three judges, seemed almost immediately to side with the state of California. The only time they really interrupted California's attorney was to bring up a Second Circuit case that also dealt with the same thing, where it seemed like the Ninth Circuit judges didn't really want to create a split between the circuit courts. And in the case of the Second Circuit sided with the state on multiple levels. Not all levels, but on multiple levels. And it seemed like the judges in this case, again, not wanting to create a split, might just take from that Second Circuit decision and apply it here, which would be very, very bad for the state of California and for carry in California.
The other question I have for you is, you mentioned that other courts have obviously dealt with this issue, and one of the recent ones is the Second Circuit, which issued, as I know you're aware, an exhaustive explanation of what is and is not a sensitive place. We're here predicting. We're not giving a final answer because this is a preliminary injunction. Is there any reason why, in that context, we shouldn't predict that the Second Circuit is right, that we wouldn't create a circuit split and just follow their lead?
Now, when the attorneys for May and Carolero, who were both absolutely brilliant, by the way, who had incredible arguments, had facts and details, and knew exactly what they were talking about, and you could tell were very educated on the Bruen decision, got their time in front of the judges, they were interrupted multiple times. I mean, they were interrupted quite a bit. As a matter of fact, when the the attorney for Carolero came up, the first thing that he really started off was that if the injunction is allowed to take place and the Ninth Circuit were to uphold the district court's injunction, which basically stops enforcement of the sensitive location aspects of SB2, the judges would simply be upholding the status quo, which is really what this is all about. And that's kind of what backs the injunction. If you can uphold the status quo, that is what the courts really are supposed to do in order to uphold these injunctions. So basically, he's trying to say, hey, if you guys allow this injunction to take place, the status quo would continue because people were allowed to carry in these places before SB2 was created. So that is the status quo. SB2 changed the status quo, and therefore people should be allowed to carry. An injunction should be put in place until this case is over, just like the district court said, right? He was cut off like midstream and wasn't really allowed to give his full argument when it came to the status quo.
Morning, Your Honors. Pete Patterson for the Calero appellees. I'll start with why this court should not follow Antoniuk. There's two reasons. One, we are on a PI. The purposes of PI is to maintain the status quo. And here the status quo is that law-abiding Californians who are licensed to carry firearms in public could carry in all these places, and we've shown at least a likelihood of success. So while this litigation...
that is the question that we're facing, is what is the
Yes.
likelihood of success? And the analysis of that question was what was at stake in the Second Circuit as well, because it also was a preliminary injunction
Correct.
appeal.
And
So so what you're really saying is that somehow because the district court said so, that's where we are, but aren't we supposed to assess independently from the district court what we think the likelihood of success is?
So here's the thing. The Ninth Circuit is trying to determine the merits of this case and which party has a likelihood of success on those merits. And so they're looking at both arguments to determine that. Now, we have that Second Circuit decision, which I think they're going to lean on heavily. And my prediction is they're going to go almost along the exact same lines that the Second Circuit did as well. Since, again, what happened in the Second Circuit and what's happening in the Ninth Circuit are so similar. What it boiled down to, however, was this whole private property thing, right? So if you were to go into a business in California under SB2, there would have to be a sign that says you're allowed to carry there in order to enter. If there wasn't a sign there that was posted for you to see that said you were allowed to carry, then that would be considered a sensitive place automatically. Basically what it does, it boils down to just about the entire state would be considered a sensitive place. So it's a very slippery slope, but I do think that the Ninth Circuit is going to try not to make a split with the Second Circuit, because if they do, and there's some confusion between the circuit courts, it gives us a higher likelihood that we could eventually take this to the Supreme Court. If both lower courts tend to agree and other lower courts tend to agree, then there's probably a less likelihood that the Supreme Court would take it up. So they don't want to disturb that water very much, because they know if it does go up to the Supreme Court, they're likely to be overturned again. And with a record like the Ninth Circuit has, they probably want to keep that to a minimum, since they're already the most overturned court in the entire country. So I think that's a kind of a very important point. So again, it's just my opinion, but based on what I saw from these Ninth Circuit oral arguments, it looks like we might see all of those sensitive locations and SB2 go back into full effect until this case is completely resolved, which would really just put a blanket ban on carry across the entire state of California. This is something we can't allow to happen. It's a very slippery slope. It wouldn't be the end of things, but at the same point, I mean, it would be absolutely terrible for the people there. It would be, like I said, essentially a full carry ban in the state. But that is my unfortunate prediction from what I saw today. So anyway, I wanted to let you guys know about that. It's pretty big news. I want to thank you all for watching. Please like, subscribe. You guys have a great day.